Good afternoon, class. Good afternoon.
Good afternoon, ma'am.
Good afternoon.
Welcome. So, like we always do, let's use our chat box, and please,
Okay.
please ensure that you mute yourself to enable us a very good flow in our class. So, of course, I sent a link to your class rep so you can actually go ahead and read on vitiating elements. We'll do a little bit on that before I go to our class for today. So I don't need to ask if you had listened to it. I know you all have listened to it because I got a message on my YouTube channel that a colleague of yours was saying, oh, that he bought a property and it was promised that they are going to do a kind of development besides it, but that they've not done the development. That means he can't. Man, now you know. So I hope it wasn't a statement of opinion. Be careful. We said a statement of opinion will not amount to misrepresentation. So it wasn't a statement of opinion, it was as of fact, and that is told you categorically, except for that. Okay, so I think we should start by asking questions. Remember I said, who is this Aisha? This is our
Don't drop my fake number. In another year word.
To you too, you are doing the same thing. You are talking. You are obstructing my class. Hey, what am I going to do with you, these people? Okay, so let me see. What can I do? I have to go to participant and mute. Okay, so I want questions now. What question do you have on vitiating elements? Do you have any question regarding mistake, misrepresentation, duress and undue influence, questions on illegal contracts? What are your questions regarding them? Please kindly put them down while I run through the work again so that, let's see. Okay, they have actually muted while I was setting it up in the first place. But we don't know what happens at times. Zoom enables and allows you to unmute yourself upon entry. I don't know why it is so. So question while I wait for.
Hi there.
So, duress to goods is like a threat to your goods. They say, oh, someone asks if I can explain what duress to goods means. If someone says, oh, I'm going to seize your goods, I'm going to seize your car, I'm going to burn your house if you don't enter into this contract with me, if you don't do this with me, that is duress to goods, to things that belongs to you. Okay. And duress to life and to person means, oh, I will kill this person, I'm going to arrest you, I'm going to do this to your family. That's duress to person. So while I'm waiting for so any other question? Okay. Excuse me, please. think I'm trying to show you screen.
I'm done with this one.
Very nice. So can you see my screen? Trying to shut some things down. That's I'm tracking today. Okay. Check should be good. Oh, okay. So has there been questions here? Okay. Yeah, questions. Right. Okay. So let's see. So it won't take more than 10, 15 minutes on this because so we can do some other things. Where's the thing I'm sharing? Where's the file I'm sharing? Okay. So you now have seen my file, although that you saw it in my in what I had sent earlier. So Gloria says, for unilateral mistake, the example of one someone. Yes, so excuse me. So Glory says that the example of one mistaking, I hope you can hear me. I may not be able to scroll down because I want to read these questions accordingly and respond to them. So the example of one mistaking someone in a contract and the person being mistaken for knows that he is not the actual person. Where is the mistake from? Is it from the person who mistook the person or the one who chose to keep quiet? The mistake is from the person who mistook the other person. That's the person who had made a mistake. It's not the person. The person that had kept quiet had done wrong by keeping quiet. So if you want to buy from somebody who owns the shop and you got in there, it was just one of these guys that goes around that was there. The person that, and you have asked, please, I want to buy from, I need, am I in the shop of Mr. Taddy? Oh, yes, you are you Mr. Taddy? Oh, yes, I am Mr. Taddy. You have, that is misrepresent, that is a mistake on the part. I'll repeat, that is a mistake on the part of the person who came into the shop, who had mistaken that person to be Mr. Taddy. So that is a mistake on the part of the person who needs to get glory. I hope you got that. So the person who kept quiet is the wrong party here. So in the place of contract in restraint of trade, in restraint of trade, a lot of the times we hear it around where you will hear that, oh, in this organization or in this trade, it's mostly happen in a trade that has to do with know-how. there is a man or there's a person that sells, and now if I can use the place of, I won't use Coke because Coke isn't using patents. And so a lot of the time, they don't even expose their client, they would have even signed some non-disclosure agreements. But then for some companies that produces things, they are some of their employers, I would like to say some of their employees, they are at they are the ones controlling the powerhouse. They are the ones mixing chemicals. They have taught them how to mix chemicals. They have taught them how to do some certain things. The idea behind it is that if you know, because some people will just learn it, immediately they learn it, they will leave the place and go and open their own shop and start doing the same thing. And so the person whom they had learned from will not be able to benefit more. In fact, what I personally have noticed is that people like that, immediately they leave the employment of that their boss. They will go and open their own and start selling at a lower price. So why the law oppose that? Or, we say contract in restraint of trade is not allowed by the law. And some of the exceptions are that in restraints of is that, for example, when there is special knowledge of this sort, when you have a special knowledge, when a trade is such that it will give another person a special knowledge into the specifics of somebody's trade, that's where that person makes his income. That's where that person hence makes his livelihood. If a person goes there, learns there, and go and open his own, it's going to affect the livelihood of that person whom he had learned from. So most of the time, people are asked to sign some forms. Maybe 5 years after you leave this place, you cannot do the same thing that I'm doing.
Right.
Another one is, but for example, somebody sold their supermarket to another person, maybe because of financial constraint. And immediately they come back up after like a year that they had sold that supermarket, because they know that people knows them in that area. People likes them in that area. They decide to open another supermarket very close to the place where they had sold earlier. The law also would allow for such exception where they would have signed in their contract that you cannot open shop close to this place in the future. So that is what contract in restraint of trade is saying, that it is not allowed. It is illegal to restrain people from doing businesses that they wish to. But some of the exceptions are the ones that are listed. What would affect somebody else's livelihood? What would make another person stop earning and all of that? So let's quickly go to some other questions. We have a lot of them lined up here. Okay. So Oliver says, someone who fails to read the electronic terms and conditions and breach them would be referred to mutual mistake. Remember, we are told you that when it has to do with, because before you actually enter into it, you signed it. When it comes to something like that you have signed, we have said it will not be allowed. It is wrong to sign a document that is not properly read. But there are a few exceptions. But this exception will not fly. This person is not an illiterate. You should have read a contract before you sign it. Okay? It is not a mistake. It will not be agreed. It will not be accepted under mistake, Oliver. I hope you understood. So, Amen asks a question and says that, what do they call this situation whereby a tenant brings in another tenant to bypass bill from the landlord? That is sublease. In most tenancy contracts, it is not allowed. This is not what we are doing here, but I just tried to answer your question, Alamin. That is sublease. I think most of the times, most of the time, so a lot of landlord would write it in your tenancy agreement that you are not allowed to sublease. But if there's no such, you sublease, it may not become illegal. It may be okay because it's not part of what you had agreed to. So Esther says, okay, so she's trying to talk to others that I didn't comply. Okay, so Oluwaseun says, signature of a document. When a party is an illiterate and does not understand what was said in the document, but signs the document, can the document be used against the party? Remember what we had said when we're treating capacity. An illiterate person, except he is forced, although in most cases, so like I was saying, okay, so like I was saying, remember we had said that under capacity, if a person signs without having read it, the other party should know the capacity of the person is entering into contract with. This person is an illiterate and you allow him to sign it. It is good that you ensure that this person gets to read it, or someone, or you get someone to read it over to them, or you yourself read it over to them and ensure they understand it. But we're saying that in a case where an illiterate mistakenly sign a document, that is an exception to the to our general rule, which says that a document that is not read but signed will not be accepted for mistake. Okay? But where an illiterate can justify the fact why he did not sign it, you can't just, even under that exception, there is exception to it. The law will not just allow people to use things, because there are times that people know, I'm an illiterate, but because I want to enjoy the right in this thing now, let me quickly sign it, let me quickly do it. The law will probe into the reason why it was signed. And that's why, because of the financial constraints of people, when they are breached in contract, they do not go to court. But it is because we don't really, there are times, you don't really have to spend a lot. You can also approach courts, mediations, and we have the multi-door courthouse, we have citizen mediation courts around. Ensure that you get information. Go online, ask for questions. How can I sue somebody to court? How can I get redress without going to court? Because I don't have money or something. You can always go for mediation. All right. So it is good that you text things in court. Do not say because I don't have the money. Ensure you use others. So I think I have been able to respond to Oluwaseun Odunton's question. So going to M.A, bluffing during pretrial negotiation be considered a vitiating. Remember we said that bluffing will not, when somebody is bluffing, you cannot say it is bluffing. You are just joking with somebody. Come, oh, this house, God don't live inside, Now you're saying that, in fact, the dead Queen of England had lived in this house before. This house is the best house that you can see. Those are bluffs, and it will not be seen as a misrepresentation, and it will not vitiate it's there. So Glory says the person who purposely misidentify himself, is that also misrepresentation? Remember, is that also misrepresentation? Remember, we have classified that under mistake. Okay? Glory, we have classified that under mistake. Let's just leave it under mistake. Except you want to say, oh, fraudulent. Remember, when we are talking of misrepresentation, it is good that we use mistake first, and if it didn't work, but then mostly it is mistake. Okay? Mostly it is mistake. You may say, oh, you want to classify it under fraudulent misrepresentation, all right? But it is mostly allowed under mistake, okay? Lawally say for apprenticeship, is a constraint of trade also involved? Yes. In cases, there are some cases of apprenticeship that they will say, you cannot open your shop close to mine. Because of course, you know the way this person sews. This person is versed that I'm using the example of tailors or fashion designers. You know how they hem their clothes, you know how they cut, you know how you've been taught how that person does his work. So it is not it is acceptable for them to say, oh, you cannot open your shop close to mine. Yours have to be far from mine. And I think that is very, very okay. So I think with this, we have trash vitiating element, but that doesn't stop you from asking more questions. I also want to ask, the link I sent to you, do you understand it properly? The links that I sent, the voice note I sent, I think I also made it available on YouTube, so you can also check it there. And I also gave it to your class reps to give to you. But then please, I want to know if what I sent to you was self-explanatory and is something that you can actually use in the future in case you need clarification. I'm still expecting your response. Okay, so more response, please. I have how many students here? 1,005 students, 1,005 students should be in this class. Although I don't think we have up to that, but then I want to know if that voice note really is good enough for you so that I can quickly go to our class today. And we can, let me check your YouTube. Okay. What is happening in YouTube? Okay, so I think we don't even have anyone here. There's nobody here on YouTube. Okay, we only have 15 people watching, but then there's no response. Those on YouTube, I'd like you to respond as well. Are you okay with what you said was when sent to you? Did you understand it? So I'm still expecting. Okay. So today we are going to be talking on privity of contracts. Let's go straight to privity of contracts. So who can speak to this topic? What do you understand by privity? You know, at times you hear when people are talking about privy, I am privy to it. And the privity of contract, that I am privy to a contract. What comes to your mind? What comes to your mind? Remember, I don't want you to go online. Don't go and search online and give to me. So Olawale says, privity of contract is when a third party is not allowed to a contract, though there are exceptions. Thank you, Olawale. I hope that's from you. If it's from you, I would have loved us to clap for you. So any other contribution? It could mean you are not aware of the terms of the condition. Good job. So thank you, Ade. I didn't get your name. I didn't get your name clearly. And I don't want to. So thank you. Okay, Adeyin. Okay, Boluwatife. I think I would prefer to call you Boluwatife. Thank you, Boluwatife. You are. That's very good. So This thing is not giving me all your names. Maybe put your matric number. So it means it's only parties to a contract that can enforce the contract in the court of law, though there are exceptions. So thank you, everyone. You have done so well. Thank you for actually giving me, responding to that question. So then let's start. So what privity of contract means, just like they have said, is that only those that are privy to a contract that can enforce that contract in the court of law. A stranger cannot come and say, oh, I have rights under this contract. Although, as at now, by now, even if you are not law student, I know you now know that in the law of contract, there are several exceptions. And the reason for this exception is such that there will be fairness. It's not just to trouble you. It's not just to give you issues. It's such that there will be fairness. The law is just trying to do what it is created for, so that it keeps moving as human being moves. We are not stagnant as human. And so what occurs last year, what is the situation last year, may change this year. So what the law is trying to do by creating those exceptions is such that if this is what has happened last year, and there's a rule, there's a law regarding that, but this year it changed, something else happened, and it infringes on another person's right, it affects another person. What the law tries to do is so that the law try to create a form of fairness. And so if we are saying that, oh, in the law of insurance, you did a third person insurance, and on a vehicle, and the vehicle had an accident. Mr. A did a third person insurance with insurance company B. Mr. A had an accident with Mr. C. But he didn't take it up. He didn't even go to the insurance company to go and, of course, they will be the one that they are expected to notify the insurance company, I have done this, I have done that. Please, I need you to repair the vehicle of this third person. What the law is saying here in some of these exceptions is that Mr. C immediately, but because most of the time before, you can always get a police involved. They would help you get that insurance, the insurance, the details of the insurance of Mr. A, so that you yourself, Mr. C, can actually approach the insurance company to claim the third person insurance and have his vehicle fixed. Although he will come up with his evidences, with his pictures and everything to back up his claim. So I hope you understand what the privity of contract rule and the exception tries to create. So the exceptions to the doctrine of privity of contract is strict adherence to the doctrine has been found to cause, has also even tried to cause some hardship, especially in commercial practice. So that's, the exception is trying to, because you cannot be strict on saying only two people that are privy to a contract that can execute it. What of in the case where the other party is not available? In cases where let me just take it one after the other so I don't overburden you. So number one, I said one of the exceptions is agency. So in a case where, because you are in school, you gave a contract, what you're expected to do, maybe a contract or something, a function, you gave an authority to a person to act on your behalf. In law, we call such persons agents. So you gave that person an authority to act on your behalf. The person acted on your behalf and something went wrong. You as the principal, you are allowed under the law, although you were not there when that agent entered into a contract, acted on your behalf. You can, being a principal, because you are giving that person an authority, you can be the principal of that person, enforce the law. try to approach that person for a redress or to continue the contract. So that is in the case of agency. Number two exception is in the place of trust. Let's say trust happens mostly in the case of maybe a person had died, or a person before he died wrote a will, and in his will, he entrusted his property to administrators, or would I to some people to administer it, and his children beneficiaries. Okay. We also call those administrators, we can also call them trustees. But then at the time of the death of that person, after the death of that person rather, the trustees were not doing what they are expected to do. The beneficiary of that trust can actually approach them to ensure that they do what they are expected to do, although while the owner of that trust, or will I say the person who had written that will or had given the trust over to a trustee, the beneficiary was not present while they were entering that contract. But then under the law of contract, the beneficiaries, the people that were expected to benefit from that trust, can actually sue the trustees to court to ensure that they do what they're expected to do. Okay, that's why at times nowadays you hear that the owners, the children of these people have sent their trustees to courts because they haven't done what they're expected to do. It is the right. So you cannot, the privity of contract rule, if it's allowed to be used, if it is used in this aspect, it will affect the beneficiaries. And so the trustees can just do whatever they want to do. All right, so this exception actually tries to protect the beneficiaries in this situation. Also, in the case of assignment, so where a person assigns something to another person, where a person assigns in a contract, assigns something to a third party, that third party that thing is assigned to can also, because they are the beneficiaries, they are, or would I say they are those that are meant to benefit it from the assignment, they can come up and claim or sue for their entitlement under it. So when it comes to landed properties too, let's say, for example, Mr. A bought the land from Mr. B family. But at some point, Mr. A had financial issues and he sold the property to Mr. C. Now, Mr. C can, in the absence or even without Mr. A, sue Mr. B to court or sue anybody to court on that same property, because they have now inherited, or would I say, they have bought the property over, even though they were not there when Mr. A and Mr. B entered into a contract for sale. They enter into deed of sale. Now, Mr. C, who is now the present owner, can sue Mr. B in case Mr. B had done anything wrong, infringed on his rights. Under the exception of privity of contract, then Mr. C can sue. Also, we've also have, okay, I should come again with what example? Okay, is it the landed one? Okay, so in the case of land property, I said, let's assume, okay, who asked me to? Okay, Glory. Let's assume that you bought a property from Nwafo. Glory bought a property from Nwafo. Now, then Glory could not, or because Glory had a lot of property, she decided to sell that property to me. Remember, under the law of privity, it only says that it is only Glory and Nwafo that can claim for rights under that contract. But that exception it says that I, the new owner of that property, can also sue for enforcement, or would I say can sue for enforcement of my rights, although I was not a part in the initial contract, but subsequently I can sue. It also applies in a place where, let's just leave it at that, okay? I hope by now you understood me. Contract of sale of land. The initial owners, in fact, nowadays you could see a land that has moved from 10 ants, or if that's an exaggeration, from 3-4 ants. If anybody had bought a property here before, or if you have a parent that has bought a property, you can go through their deed of assignment. In their deed of assignment, we used to call something recital. That recital will give you the meaning of recital in an ordinary layman understanding. It means history. In that history, it would have told you the real owner of that property, how we move from the real owner to another person, another person, another person. So in that case, you cannot say because maybe 10 generations that were the ones that contracted, then the recent person who had bought the property cannot sue. The exception says they can sue. We have also have some exception under statutes. For example, so Adeleye says, what if the buyer who bought the land is not aware of the restrictive covenant of the land on the time of purchase? You are expected to know, and that is why you should also have the deed of assignments. Their initial deed of assignment, you also have it for yourself too, so that you can read all their terms before you decide to buy it. And we also have something that we call indemnity clause when it comes to deed of assignment like that. Indemnity clause will say that in case there is a problem on this property that I cannot solve, I would have to, that emanated from the initial buyer. The initial buyer would have to would sell, or would I say, will return back, will indemnify to the recent buyer whatever they have sold, or whatever problem is going through. It will indemnify or will help him through. He said, what if the deeds were manipulated? Oh, of course, if it has been manipulated, the court will be there. That is illegal. That is what we call, that's an illegal contract. On that basis, you go to court. The person who had, the other people will also come to court. They'll come and show the court the real deed. And through evidence, through examination of witnesses, looking through documents, the court will be able to know who is saying the truth. And damages will be paid. The court will punish the person that is wrong. Okay, somebody says I should come on indemnity clause. It is not what we are here to do. We are not doing land law. But let me just explain. I said, someone said, what if the other they've manhandled, or the initial buyer did not state all the things that they had mentioned during the contract. I now say there's something called indemnity. That means you will indemnify. You will return back to the recent buyer their money if they later discover that you have done something wrong, or that there's a problem on this property. You will give them back their money. You will indemnify them. So that is what it means. Okay? So let me go on that statute. I was explaining statute. Okay, so what I mean by statutory exception is that there are some times that today there is no law, or there is a law saying do something, and tomorrow they can come up with another law saying that we should not do that thing. That means if the law of contract today is saying we can do this thing, there could be an exception for it tomorrow under statute, under new laws, saying that thing is not acceptable under the law again. Okay? So other bankers' commercial credit. This used to happen in this case. I would, who is this person that is obstructing my car? When you do this, just take the whole flow away from me, please. I hope those on you can hear me. Because it seemed my network went um can you see what I'm sharing? I think I have to share over again.
No, ma'am.
Okay. Remember, you're not to talk. Mute yourself. Thank you. All right. Long way to go to there. Okay. Okay. Okay, you should be able to see my my screen now. Finish the review. Okay, so for bankers commercial transaction, commercial credit, what it means is that there are times, I hope you can hear me. I need your response here on my chat, so I'm not speaking to myself. Excuse me, please. Okay, so let's just keep going now. So for bankers commercial credit, what it means is that, see, there are some times that in order to to give some people that you are into a contract with, in order to let them know how serious you are in some businesses, what they do is that they will have they will have a kind of they will open an account for the benefit of another person, of a person that they have entered into a contract with. And when they open such an account, that means that person can go and be getting getting their money on that same contract from that bank account without even having to ask from them. They are free to go and take it. So what it means is that they would have dropped the money there. It's just for the bank. As they are going on with their contract, as they are doing their contract, they'll be giving their money from the bank, will be paying them their money directly, not will be paying their money, not the person who had entered contract with them. So what we are saying here is that it is not the person, it is not only the person who had opened that account with them that can sue the bank. The person on whose behalf that the account was opened for can also sue the bank in the process where the bank had refused to give them the money. So that is for privity of contracts. Let's quickly move on to discharge of contract. Let's quickly move to discharge of contract. So under discharge of contract, so Adeyinka, this the gentleman, please can you just allow me? I want to conclude this thing, because I know there is a class that after my class, we also have another class. I want us to conclude what we are doing. We still have like 40 something slides, you know. Just give me a little bit of a time. I'm going to respond to your question, okay? Thank you. So let's quickly look at discharge of, that is for privity of contract. So by now, you know, as a general rule, that only two people or only the parties in the contracts that can enforce the contracts. Excuse me. So today is a very good day. My network is just going back and forth, but that doesn't stop us. We'll keep going till we are done. All right, so share it again. So we are talking about discharge of contract. So, like we had said in privity of contract, our last statement, when we are talking about all of these contracts, what we have done so far. In most cases, whatever has a beginning also has an end. I'm not generalizing, I'm saying in most cases, and so it goes ahead. It also applies in the law of contract. If something starts, then it should end. And that's where we're talking about discharge of contract. Now, but the way, don't worry, just ask me after I'm done with my classes, then I will explain to you. Okay, but I want to ensure that I'm done so that I will not eat into your time. Okay, so when we talk about discharge of contracts, there are different ways that contracts can be discharged. Discharge of contract means if you start a contract, that is, discharge of contract could also mean termination of contract, the end of a contract. But the question is then, how can we terminate a contract? How can we discharge a contract? We say, number one, we can discharge a contract by performance. You can discharge a contract by agreement of the parties. You can discharge it by frustration. And it can also be discharged by breach. So let's take it one after the other. Discharge by performance. So discharge by performance mostly is that you both agree on it. You entered into that contract. Okay, I hope you can hear me now. So when we're talking about by performance, you both entered into a contract and you both performed to your end. Okay, so today's a good day, okay? Today's a very good day. So the contract can be discharged by performance if the both parties had performed their end, they have performed their obligation in the contract. That makes the contract discharged. And I'll give you an example. If we can remember, if I'm going to give you an example in an executory contract. In an executed contract, it's very simple. You went to a supermarket, you bought goods from them, you paid, you left. That is discharged. You have done your part, they have done their part. And so if we want to use the example of, remember the one I gave you of a colleague of mine who most of the time used to pay, which immediately on the first day of our resumption, she would have gone to the restaurants, make payment for the whole 3 months or a month, and be eating subsequently. In that case, it will be performed. It can be discharged by performance if after the end of their maybe a year, a month agreement, they've supplied all the food to her. She went home happy. They also are happy that they had collected their fee. That makes it good for the party, and that is discharged by performance. You entered into a contract, it was discharged by performance. Also, the law comes to also recognize 4 exceptions under this rule. Okay. We have, in the cases of maybe divisible contracts, there are some contracts that you may actually say, oh, when you do this one, it follows by this. It could be that you got a contract to do like 10 things. And they say, oh, when you finish doing this one, we are going to pay you for doing it. When you finish doing that one, we are going to pay you for that. Those are severable contracts. And it is an exception under it is that the reason for this exception is that you really do not have to finish the 10 things before you can actually say, oh, you are discharged. You can be discharging it individually or accordingly. When you finish the first contract, it can be discharged and so on and so forth. It may not really have to do with you doing everything. Also, in the place of partial performance. In partial performance, if you have done a partial work that you are expected to do, the court can be accepted if you both agree, in the place where the both parties agreed that, oh, with what you have done, you can go. It's okay. Or that, oh, just give me the remaining, then I'll let go of what you have done. Also, in substantial performance, it could be that you want to paint a house. The person had finished painting the whole inner part of the house, but hadn't done the outer area or hadn't done the sitting room. Or could I say, haven't done maybe the visitor's toilet. You could say, oh, you both can agree that he can go based on that. Though it can attract some additional money from you. You could, I mean, from them, they may have to return some money to you, but then you can agree that with what you have done partially or substantial things that you've done, you can go. Also, in the case where a person is prevented from performing, what they ought to have performed, then that can also enable them. That can be a kind of exception to the rule. I'll give this example. You all agree that it's agreed that you should go and you agree with a painter to go and paint your room. But by the time they got to the place, they couldn't access your room. And that has been going on for maybe 4 or 5 months that they are going there. You can both agree that that is enough, that they can stop. Although you may say, oh, maybe out of 10,000 naira that I've given to you, you can take 2,000 naira as maybe and give me the remaining 8,000 naira. Anyway, those are the exceptions to the case of discharge by performance. Of course, partial means you have just done a little. Substantial means that you have done a lot of it. I hope you understood. Okay. Okay. So, another discharge is discharge by frustration. Okay. Discharge. I hope you understood discharge by performance. In law, but going back and forth actually will take my time. Okay. In law, discharge by performance, it means that when you want to discharge by performance, it has to be exactly what you have agreed to. But we don't say there are exceptions to that rule of being the exact thing you agreed to. And the exceptions are the things that I've listed. When the parties agree that it is okay to do substantial work, yeah, it can also be seen as performance, okay? Okay, so let's look at discharge by frustration. You know, there are times that you cannot just perform your end of some contract because one is frustrated out of that contract. You know, and so at some point it can be seen, that frustration can be seen as discharge, as that parties have discharged their part of the contract. Number one, when the subject matter of the contract has been destroyed. Okay, you entered into an agreement with a performer, with a singer, that they should use your hall, but then, or that you as a singer, or as a class, you want to hold a conference, and you enter into a contract with the owner of a space. But before the day of the conference, the place got burnt down. Frustration, you cannot go ahead with the contract. It is not the fault of the owners of the place that it got burnt down. And neither but then they have no option. They cannot fulfill their part of the contract again. It also goes to the place of non-occurrence of an event. So I'm giving I hope you'll be able to understand my example. It's just as short. Let's say, for example, you agree, you told your classmate that, come, let's watch this football in my house tomorrow. You all agree that but before tomorrow, let me buy NEPA. Is it NEPA that we use now? IKEDC or whatever. Let's buy something in order that by tomorrow we'll be able to watch it. Let's also buy fuel in the generator. But that tomorrow, the match did not take place again. I pray nothing happened to player, but maybe something happened to the players and all of that, and the match will not take place again. So in that case, it is by frustration that agreement for you to go there and go and watch that game or that match is frustrated by the fact that the match did not take place. And so you may not have to go to the person's house again, and it's not their fault that happens. Number three, where there's a change in law. Okay. Where yesterday something is actually lawful. It is lawful to drink, to use disposable, using, if you can remember, this foil disposable plates that we use in the time, like maybe 6 months or some months ago. It is lawful then for us to use it. But you now enter into a contract with somebody that for the next 10 years or for the next 2 years, you'll be supplying me these foil plates. And at some points, the law now in Lagos State, I know, you cannot use that foil plate again. It has now become unlawful. So they may not be able to perform their end because it has been frustrated by the law. Also, in the case of personal incapacity, where you enter into a contract with somebody and the person died, you may not be able to retrieve your money back or whatever, but then you just have to accept faith. It can also be, frustration can come by illness as well, or where you have to take up national service, which can affect individual service, because national comes, the national interest comes before an individual interest, especially in exigent cases. Also in the place of government interference, and also in the case of outbreak of war. And I made an example of course, the 2020 pandemic is like a war to us as well. You may have entered into, it's like health war, is war against our health at that time. And so we don't want to go out into the streets. And so a lot of people entered into contract as that, but then it was frustrated by the pandemic at that time. Okay. So also, we have limit to that doctrine. Okay, because at times, some people just come and just do things. In fact, some people try to create that scene of frustration even when there's no frustration at times. They try to self-induce frustration. In such case, when such cases are taken to court, the court will be able to detect self-inducements and all of that. Even another exception is that there are some things that, although it may be burdensome, you may not be able to perform your side because the burden is too much. It doesn't mean you should not go ahead and perform it. You can always bypass the burden and try to ensure you do your part of the bargain. We also mentioned the place of temporary impossibility. The fact that it is temporary doesn't mean you cannot go ahead and still do it when you are able to do it. So those are the limits to the doctrine of discharge of discharge by frustration. You just don't see everything as frustration. What this exception or limit to it is trying to say is that try to find a way to ensure that you do your own part of the bargain. What then is the effect of frustration? What happens if there's frustration? That's what we are trying to say. So where frustration occurs, the contract comes to an end. That is it. When somebody dies, somebody that is expected to, let's say, for example, a person that is expected to repair your television for you, you have paid. In fact, God forbid, it was when he was coming from the place where he went to buy those things to repair it that something happened to him. The contract has come to an end. I pray nothing happened to any of us in Jesus' name. So that's just an example. So, also, those are the cases here. The effect of frustration. You know, some people as now, you know, under the common law, the effect is that the discharge will end the contract. The discharge will end the contract. All right. You know, the loss lies where it falls. That's what the classic thing that where there's a loss, everything just falls at that time, at that place. You know, but in some cases, money can be retrieved. You can actually get a kind of redress. You know, and so I made an example. There's an example in this case where maybe before the pandemic, two people enter into a contract that you are going to build a place for me. Although that person had bought part of the things they are meant to use it. Maybe they bought cement. I think then we're at home for like 3 or 4 months. You had paid maybe 10,000 naira to buy the cement. The person bought half cement and hadn't bought the remaining. And while we're at home for the pandemic, I think there are some cement that will turn rock. Maybe the cement at the one he bought at turn rock. Doesn't mean you should not return the remaining money with him. So that is what we are saying. Although the effect is that the contract will end, but that doesn't mean there is no redress. There could be a redress in the case where maybe you can still actually get the money that hasn't been spent. All right. Also, we also have discharge by breach, and this is as simple as ABC. You know, if a contract has been breached, then what it means is that, okay, if there's a breach in contract, that has discharged the contract. The person whose right has been breached can then go to court, can sue to court for damages. And so we have anticipatory breach, and we also have actual breach. So actual breach arises when a contract is still not performed on the dates agreed by the parties. But there are times that in your mind, you You are seeing something that something is happening, and it seems that this person may not do this. You can quickly go to court. So I'll give you an example. An actual breach is that you both agree today that I'll pay you 20,000 naira, you give me your phone. After paying the 20,000 naira, the person did not give you the phone back. That is an actual breach. But there are some things, this one mostly, it mostly happen in maybe executory contract. You know, you are giving somebody a contract to build a house for you, and you are paid. You paid for the materials, the raw materials that they would use. And after making the payments, you have agreed that they will use Dangote cement. And it went ahead. I'm sorry for using that name. I shouldn't be doing that. But then let's say there's a specific cement that you all had agreed to. He didn't buy that cement. He went to buy an inferior one. Immediately you see that instead of doing too much of waiting for a long time, you can quickly indicate to the person that this is not what we agreed to. And if the person would not agree, you know, some people would say, but we have bought this, it's not our fault. You can quickly sue the person to court so that the courts would either correct that person to specifically do what they are expected to do because that specific performance under remedies, or the court will say, oh, stop, you can decide to stop them from going ahead and pay you your money back. So that is breach in anticipation. We call that anticipatory breach. Okay, so going to our final topic, that will bring us to the end of this class, is remedies for breach of contract. And so, you know, we've been talking about discharge of contract, especially when it comes to the place of breach. Then how can the other person whose right has been breached, how can he get redress? How can he get succumb from the law? He can get this redress by remedies. There are a lot of remedies that is available under the law. And so we have damages, we have injunction, we have specific performance, and we have rescission. You know, damages can be in form of monetary and a lot of it. We have a lot of ways that this comes in. We have the one for nominal, we have nominal damages. Those are like simple damages, that money that is not too much. So, but when we're talking about damages, the law look at remoteness. How remote is this breach? If this breach is not that much, then maybe you can give the person like a nominal damage. But then if it's that, it is so much that you cannot go but do it. It is a very, very severe breach. Then it is now the law that will be able to interpret this and give the innocent party, the aggrieved party, the succumb that they need. You know, why we try to actually nail on this is that, you know, what is remote to Mr. A? Remoteness of a breach to Mr. A may be different from Mr. B, and it depends mostly on financial capacity. Somebody can decide to say, oh, he fumbled, he didn't do this thing very well. I paid him 50 million naira, he didn't do it very well. Please let the guy go. I just don't want him on my property. And somebody, if it's just 5,000 naira, they can they can cry. So that's why we are saying it is now left for the court to determine remoteness, to determine how much this is remote, how much this damage is to parties in a contract. So in this last sentence, we said that a line has to be drawn between loss, which is a direct consequence of a breach, and that I will not let this person disturb me. Okay, so let's look at also when it comes to measure of damages, how then can the court measure damages? How then can the courts measure damages? So it is a problem. We have a problem when it comes to the place of measuring damages. How does the court quantify loss? You know, how can you translate loss to money? You know, there are times, even if you have paid 15 naira yesterday or 15 naira 6 months ago, it is not equivalent to the recent 15 naira. 15 naira nowadays it cannot buy anything. So then how can the courts then quantify that? Okay. The problems of remoteness and measure of damages are easily determined if the damages are liquidated. So I mean liquidated is if you can quantify it, if it's in form of money. If you say, oh, I gave him 50,000 naira last week, you know, that is quantifiable. The court will just grant the 15 naira damages, except for in a case maybe you paid them 50,000 naira last month or 4 years ago. You know, that's, you can then say, oh, my lord, we want the court, the party to also pay damages in form of interest, the interest that would have accrued on that thing if this person had paid. Okay, that if this person had done what they need to do, then there may be no interest. But then this, they have not done it, then my lord should. But except for that cases, for those cases, the law can quantify it by looking at, in the case of liquidated damages, that is, you can quantify it. You can say it is 20 naira, it is 30 naira. There's a specific sum that you can use to quantify it. But in the case where there's no specific sum, we call that unliquidated. So unliquidated damages, they are damages which have not previously been assessed or provided for in a contract. You know, you may not even have foreseen such damages. If that damages happens, then it is now in the hands of the court to determine what should be the damages. You know, the law may look at the circumstances, may look at what has suffered, what the innocent person has suffered, then quantify it into money. Okay. So that is for measurement. So like I said, damages can be measured in liquidated or unliquidated damages. And I said liquidated damages has to do with specific sum, a sum of money that you can state that is specified. Unquantifiable is the one that is not specified. And in that case, it is the court that would assess it, that will be able to know which is which, it's the court that would then quantify it by themselves without being, although the innocent party can come up with some things that can help the court to quantify it. Then let's look at a situation where a loss can be mitigated. So the common rule is that injured party must take all reasonable steps to mitigate or minimize loss. You know, in this part of the world, especially when you know you have rights, people will even be praying that you breach a contract because they know how much. Anyways, I won't say in this part of the world so much because this part of the world, we are so not keen on going to court. But looking at the people, like, for example, talking in for those in Europe, they will be waiting for you to even reach the rights so that they can quickly run to court and get this lot of money that they want. So the general rule is that even if something is happening, as a person, you should try to see how you can mitigate that loss. You are giving somebody a contract to build a property for you. They went to buy something, inferior things that you know you didn't agree to. You were watching them. You want them to at least use it. And at least the house should break. This should happen before you can go to court. the court will also look at it and ask you, what have you been waiting? What have you been doing? So there should be a way that you yourself, as the owner of this thing, should be able to mitigate the loss that will be incurred. So if you refuse to take step as the owner of, as a person in a contract, it can actually affect how much you can prove your case in court. You know, you wonder how simple it is that we are saying all this here. When you go to court, you have to prove everything. If you want damages, you have to prove every dime that you get in court. You know, in law, we say something. We say that the court is not Father Christmas. That you just go there and ask and they give you. You have to prove it in fact, to a reasonable man standard, all right? Okay, so another remedy is injunction. And injunction comes in the place of, let me give you an example, because examples will work better. So where you are giving somebody a contract to build a property for you, and the person is using inferior products, you can go to court to stop the person from doing that, from building further, because you know it's going to affect your building. That is what we call injunction. Injunction is like you asking for a stop in whatever that is presently happening. So it is a decree of the court to restrain an action from further happening, so that the breach or the damages will not be too much. So that is for injunction. So injunction is refrains, is when a party try to approach the court to refrain, to restrain another person from doing some action that can affect or that can further bring about a breach of contract. So another remedy is specific performance. I would also still use that building example. You can go to court for specific performance, you know. So what we do in court most of the time is that you have all of these things in the same claim. Your first claim could be an injunction. Your second claim would be a specific performance. You could say, oh, my lord, in your processes before the court, you could say, my lord, we ask that the court restrain this person, the builder, from, except that they use the specific performance to ensure that the court make them to perform the specific of So sorry, I'm back. That was an internet issue. Okay, so at that we had explained specific performance. That is you asking the court, okay, to order or to direct the infringing party, the party that is infringing on your right, or the party that is doing the wrong thing, to specifically perform what you both had agreed to. We have agreed that you use this product to build this property. So you can ask that the court that after stopping them from doing what they have been doing before, we now ask that the courts make sure that they do the right thing. That is for specific performance. Okay, so the next is quantum merit. So this phrase is a Latin phrase. What it means generally is that it means as much as a thing is what. So what it means is that a claim made where a contract makes no express or implied provision for remuneration. So it will be saying the court should give you what a thing worth. So let's say, for example, where a person performs a service for another, or that he bestows a benefit upon him without being under any contractual obligation to do so, a party to a contract may be unable to fulfill the entire obligation. So if he's unable to fulfill all the obligation, then the court will now look at what he has performed as against what is yet to perform. Then the court will now be able to put it under like a quantum merit, something to look at the merit of the case and be able to know the specific of what should be given to the person that their right has been infringed upon. Okay, so that's for the case of quantum merits. You can start putting in your question. We are done. No. Okay. So the last one is rescission, and this mostly happened. Remember, we mentioned the rescission when I was talking about misrepresentation. When I was talking about misrepresentation, I said under misrepresentation that under innocent misrepresentation, that the other party that has suffered loss can be granted rescission. And that means that you would actually return back the amount, especially, let's say, for example, a contract where you both agree that you will supply me 20 bags of rice and I'll pay you, and I've paid 50,000 naira. No bag of, I'm just saying anyway, that's an example. So what rescission means is that in such an innocent misrepresentation, so the innocent person who has misrepresented would give the person that has suffered loss back his money, which is like giving back 50,000 naira. And we have said that in most cases, rescission may not, especially in innocent misrepresentation, rescission may not go with damages. Why? Because it's innocently made. So the courts will not be open to actually giving damages, although you may have suffered additional damages, but it is only that 50,000 naira that you had paid initially that is the rescission that you expected to pay to the person that had suffered loss. So because in most cases, it may not just be the loss, you may also may have incurred some damages. But when it comes to innocent misrepresentation, it's only rescission that is allowed. So someone said I should explain quantum merits again. So let's just go by this. This Latin phrase simply means so much as the thing is worth. So much as the thing is worth. That the court, when he is granting remedies, when the court is giving remedies, the court should give so much as that damages is worth, or as much as that thing that has been lost is worth. So it is a claim made where a contract makes no express where there is no express or where there's no implied provision for remuneration. Okay? So there's this, for example, you told somebody that oh, go ahead, go and repair the glasses. Or go ahead, go and repair my what do I know that students use a lot now? Okay. Now, presently on campus, students are not really on campus, you know. So all these businessmen, in fact, a little people, those few people that they get, they try to treat them well and all of that. And so your phone is bad. You try to approach a person. And while you approached him, you guys, you know, he was so excited that you even came to his shop. He didn't even talk about the price. He went ahead, repaired your phone for you. And maybe he had included something, he bought some things. And by the time you got back, he said, you pay 10,000, and you were like, But I thought it's something like 500 naira or 1,000 naira. And the man said no until that. If such a case is taken to court, the court will use this quantum merit situation. And the court may ask, oh, what have you bought? What it means is that the court should give what that service worth. What is the worth of that service? Now, it may be good on the part of the person who is claiming for that thing to say, to bring another person, an expert in that field, to come and tell the court what that service is worth. You know, and if a person is unable to produce that, he may not be able to get what it is worth. So I would prefer, if I were the person in the shoes of the phone repairer, I would rather go with an expert that would tell the court what my service was worth, even though we hadn't agreed on the price. Okay. So Olawale said, yeah, let's use the example of hot plates. And the person said, no, it affected the elements. Remember that the school authority should not know you are using hot plates. I don't think you're expected to use hot plates. So I'll stay at the phone, the one that I think is acceptable, okay? So that is for law of contract. We have come to the end of law of contract. Now we have like 12 minutes to talk. So I want questions now. Oh, you are allowed to use hot plates, not gas. Oh, okay. Okay, that's fine. I think in my school, I don't even want to go into that. Okay, so let's look at David. Esther says, in the case of unliquidated damages, can the injured party determine their compensation? That is, one that would be suitable for them. You know what? I would have, even if I were that person, why not use these quantum merits, bring the court to the notice of these quantum merits and say, my Lord, I would ask that the court give us what this thing has worth. And if I were that person, I would call expert witnesses, people that knows the area of that contract, that thing, whatever you have contracted, you know, people that are good in that area, that does business. You can call expert witness to that effect, and they would give the court the actual amount that is expected to be paid. David Esther, I hope I've answered your question. Okay. Someone is asking for material. Oliver, you want me to give you material when we are giving you material to go and, you know what about this material thing is, even if I release my material for you, it doesn't mean my questions will be limited to it. Remember, as a university student, and that is what my senior colleague was trying to explain to you the other time, you know, students would then refrain themselves to just reading just what, because my material, this is just a slide that I just tried, you know, I gave explanation, I do, okay, look at this, there are some places that I just give a word to explain something, and I'd explained it with 10 sentences, and you go and be reading based on that. So that's my issue. Even if I give you my material, you are going to read outside of my material. We have given you textbooks to go and read in order to make yourself better in this area of law. And like I used to say, you know, nobody in this life, nobody can say, oh, this contract is not for me. I won't do it. You know, you contract every day. Being the student that you are in management. In fact, bulk of your work is on contract. So you cannot forgo contract. You have to sit down with it, especially during these holidays. Sit down with it and read it very well so that you can acquaint yourself with it. Or would I say, so that you can familiarize yourself with it. Any other question? I think this place, there's no question. So I'll think and I'll see if I can release this material to your class reps. Okay, you said I should explain statutory exception. Okay. So remember we said in statutory exceptions, there are times that what is made law, what is acceptable in the time past, with statutes, it may actually, there will have been a redress. So if something is allowed last year, or last year something is not allowed, the law can now make it approved. A new law in the place of a new statute. What I mean by statute is law. You have done this at the beginning of your class. A statute can make something that is approved or acceptable, make it unacceptable or approved now. So that is when we're talking about statutory exception. I think there are no more questions. With this, we have come to the end of contract, and I wish you a wonderful holiday. And I want you to also ensure that as you're enjoying the holiday, read as well. So yes, please go ahead. We still have like 7 more minutes. Victor, you have a question, so please go ahead. Okay, so you said I should explain anticipatory breach again. So the anticipatory is taken from anticipate. Anticipate means something that you have foreseen that may happen. Okay? And so I gave the example that let's assume now that Victor, you gave somebody a contract to build a house for you. And while you were signing your contract with the builder, you are told him, these are the materials that I want. Oh, I want this type of cement. This is the best cement in town. But you know, of course, as the owner of the property, you would always go there to go and check on what is happening. You got there one of these days and you notice they were using inferior products. Of course, that is a breach to your contract. And immediately you saw that, you will quickly call him. You anticipated that there's a breach coming. If he uses this inferior product, it could affect this building he will be building. This building that I have given to him. You've anticipated it. It's an anticipated breach. It's going to affect your work. Then you can quickly approach the courts. You know, or maybe you got an info from somebody that you want to buy an inferior product. You can immediately alert the court that this is what is happening. And being anticipatory breach, you will quickly get redress from the court. You will get injunction from the court. You can also get specific performance from the court. I hope that is okay. Okay, so Olaiton said we should talk about rescission. What we mean by rescission is this, and it mostly happened in innocent misrepresentation. Or other, is another breach. What it means is that you will give back to the person that's at loss, that had incurred loss. You will give back what you have been given, only what they gave to you. And I gave example. Let's say in the case of innocent misrepresentation, in the case of innocent misrepresentation, this person told you that I am importing some clothes for children, but I need you to pay before the clothes come in. I want to use it to clear, to clear the items from the pot. And you have agreed the clothes is 50,000 naira. You made the payment. But unknowingly to you, while the clothes was coming, something happened and it got drowned. So by the time the ship got to Nigeria, the items didn't come together with the ship. That is not a breach that happens at the end of the seller. It wasn't a purposeful, it wasn't intentional breach. It was innocent. So what is rescission there is that, remember, the buyer would have been waiting for that item, even over the time. If he had used that 50,000 naira for another business, he would have gained more. But what rescission says is that you cannot take more than the 50,000 naira that you have given him. He's entitled to give you that 50,000 naira. Give you back your money, give you back what you have suffered, but cannot give you, but then you cannot take additional. So rescission means giving you back what you have contracted in the first place, okay? Returning you back to how you were in the first place before you enter the contract. Alright, so I hope that is okay. So that brings us to the end of our class. We said it is more like indemnification. It's okay, but really, indemnifying somebody can be more than that. You can prove more than that. So like I used to say, try your best not to put all these things together. Let indemnity stay on its own. Let rescission stay on its own, okay? Indemnity can be more than what you are saying, okay? All right. So, damages for pain or suffering. So I don't understand what you mean by damages for suffering or something. I don't understand. But then, do have a wonderful holiday. Take care. Bye.
Thank you, ma.
Se for